Para 15, may I, my lords? Bringing my minor son and daughter to the honorable court after tutoring, traumatizing, blackmailing them is not in their best interest. Exposing him at this tender age to an open court environment and witnessing their parents in conflict in public will create lifelong scars in their young minds. And para 11, they state that respondents' counsel emailed my counsel at 6:55 stating the children had a party and refused to go. The email suggested a pickup at 8 p.m. And my email clearly says that they can be dropped next day. However, there has been no response to the email at all.
Lords, if there was a party, they should have told the previous day that there's a party the next day. Please come at 8 o'clock. Lords, most importantly, the children are just 5 years and 3 years old. Party till 8 o'clock is quite unimaginable. Lords, finally, the children are affected. The children are so fond of the grandparents, so fond of the father. The father has just come out of a brain tumor surgery. And for him, his only solace is his 2 children. Unfortunately, my lords, the parent is not taking the interest of the children in mind. And I've come to this court.
But the earlier weekend, the children did spend with the father.
The earlier weekend, the children spent with the father. It went off very well. It has been recorded by your lordships in the order dated 22. This is nothing but an after effect of that. My lords, the order has to be respected. Your lordship, my lords, is exercising jurisdiction under the parent patriarch and contempt jurisdiction. If my learned friend is not following the order, my lords, we don't want punishment. Let the custody of the child be given to us. We'll give her 24/7 access to the child, which will be in the best interest of the child. The children, my lords, need both the parents. Joint parenting is the rule of the day today. All courts, my lords, ensure that that is done. If she is not able to ensure that, we will ensure that, my lords. We don't want to restrict her from the children. We will give her 24/7 access. If she doesn't, this order, my lords, was challenged before the Honorable Supreme Court and the SLP was dismissed. And we have filed it before your lordships. And this was not disclosed to your lordships.
Plus, para 11, they state, sending an email at 6:55 on a Saturday night outside regular hours further suggests questionable and malified intent.
The short point is to implement the order of 12/7.
Do you want to go for
Let's,
mediation?
I did,
My lords,
Do you want to go for mediation?
my lords, when she is
think that would
blatantly
be-
violating the court order, we are not sure where it will lead to.
because I think there has been.
Because of your lordship's blessings and interference, the children came to our house on 15th and
Don't give
16th.
less. First of all, we don't give blessings to anybody. So, be precise in your submission. We don't give blessings to anybody. Phraseology and submission of the kind in the court of law is not warranted. So we are asking whether you are going to opt for mediation.
Since mediation has not happened in this case, I would definitely urge for the parties to go for mediation and work out what are the modalities, and I think it can definitely be worked out, my lords, is my
Coming
suggestion.
from outside?
My lords, I come from outside.
So that is not the language of the High Court of Karnataka,
I'm sorry, my lords.
and never was the High Court of Gujarat. That you seek blessings from the judges. Please don't use such words. Yes,
Yes, I'm sorry. my
I'm
lords.
very touchy about your submission, the language of submissions. And what kind of awareness you are making in your affidavit today?
My lords, as it's a custody issue, the tempers are high, my lords, emotions are high.
No,
I'm
no,
sorry,
our tempers are not high.
My lords, the parties.
Parties
I'm
temper.
very sorry.
So tempers are high and that is reflected in paragraph.
Yes,
Mr. Counsel, don't be smart
yes.
and don't cast any assertion, whatever comment we made, in whatever tone we made.
My lords,
It is not the tempers.
my lords of the parties, my lords, I'm sorry. of the parties.
We understand what you are trying to judge, Mr. Counsel.
Yes, ma'am.
So what kind of averments you are making in your affidavit? Look at the page. Any breach of discipline, I will never, discipline in language, I will never tolerate. Yes. What is paragraph 7 in your affidavit? What are you saying? Why you are making such averments? They are not preventing. Who says that reference is made to only unjustified
even
demand by
earlier,
the respondents'
There's
counsel
such
that
kinds have been,
parents, grandparents, children with them, deeply attached, be kept out of proposed interaction with the court.
this even earlier they have made this, my lords. Everywhere they have made the same
We have
thing.
not said so anything.
And when
We
it
only
comes,
said in our order that the parties have agreed to keep the clients, respective parties along with the children present before the court on 27 to 25.
absolutely.
And what you mentioned was also not right, madam.
My lords, I'm sorry, my lords.
And in the
Afternoon,
decline-
I'm sorry, my lords. It's because they have been making allegations against me. And I do not want to come across as somebody who's
you-
subjecting the
you
children
might
to.
suggest that
I'm
they are not-
extremely sorry. Yes, I do understand, my lords. I do understand. I'm
you
extremely
suggest
sorry.
That they are against bringing the. judge.
They are writing here, my lords, even at para 12, they say in the current,
That is not the tenor. They are saying that you are trying to prevent the interaction.
no, my lords, at para 12, they say it is not conducive to have any interaction with the respondent or for this court to have an interaction with the children. My lords, para 12,
Try to go for mediation. How to take instruction.
That's one.
well, it's one mediation, I think is,
Frankly, very frankly speaking, notwithstanding the orders, if either of the side, kindly listen. Kindly listen. Very frankly speaking, notwithstanding our order and notwithstanding your agreement recorded in the order that they will bring the child here for interaction along with the parents. Any shade of reservation, unwillingness, disinclination to bring the child before the court, we are not interested.
because I've always
Then
been
it
ready and willing.
is only our moral and legal duty to forge some alliance
Absolutely, my lords.
and affection to solve the issue that we are interacting.
Absolutely, my lords. I'm
We are
grateful.
otherwise not interested.
In fact, I'm grateful for the
They are not
indulgence
interested
of
in the
this court.
process and the resolution, we are not interested. So kindly make it clear whether you want the order to be implemented. Otherwise, we'll argue, please argue the matter, we'll take it to logical. end.
Plus, I'll file an I'll file a reply stating that it can be complied. There is no difficulties. However, sometimes when the child has some like birthday parties or something, the child will want to go late. That should not be an
This,
issue.
as counsel is rightly saying, in a different way, though in a different expression, everything court go on recording everything in matrimonial matters and these matters, custody matter will not be proper. Many things go without black and white, out of understanding, out of the nature of the matter, human relationships. So what do you propose you tell us on the next step?
If they are agreeable for mediation, I would definitely, my lords, I would pray your lordships to refer this for mediation because it has not gone at all, even for once. So I would say the parties can work out something before the mediator, a skilled mediator, my lords.
The children are mingling with the father very well.
My lords,
The children
Well,
are
the parties
well,
are here.
very well mingling with the father, as the photograph suggested.
yes, no difficulty. He will be sent, my lords. That apart from that, if mediation can be attempted at by the parties, I think it can resolve all the issues between them because there are several petitions pending between the parties. So one mediation, I think the parties.
See, the photographs reveal that the kids too love their father.
Definitely, my lords. Yes.
But in this affidavit,
No,
of
no,
course,
it was
filed
only-
by them,
Yes, my lords.
of course, filed by them. If the boy shouts from the balcony, I don't want to come, you go away.
He's not shouted like that. Milords, what has happened?
If that is true, it
No.
only indicates that his mind has been poisoned.
No, Milords, he is told that I'll be coming
In
late. They
the,
didn't wait for
in
him.
the interest of your own children,
Absolutely.
you are advised not to poison the mind of the children
Not at all. Yes, my lord.
against both the parents. It's
True.
very essential. It's very essential.
Plus, he did not shout like that also. In fact, they have stated that. He only said, I'll be coming late, which they did not wait. They went away. And unfortunately, they did not even come to pick up the children at 8 o'clock. In the email, Milords, it suggested that they can keep them overnight, in fact, keep the elder one as ordered overnight. That is not done. Plus, that compliance, I've already advised my party. That should not be difficulty, Milords. But apart from this, if this can be referred for mediation, I think a lot of
And
matters could
you
be
should not
sorted.
be casting aspersions on the council for
Absolutely, absolutely,
response.
absolutely, absolutely. This was,
This is not
Yes, ma'am.
what
Yes.
is expected.
yes, ma'am.
So that's improper.
Yes, ma'am. Yes, ma'am.
Plus, any date that your lordship,
That's right, but what is in the meantime?
Milords, may I suggest this, Milords? What fell from your lordships? Milords, lordship may have this matter after 2 weeks. Let them comply with the order for the next 2 weeks. Then we will get back on mediation, which will be a positive. Let them comply with the order.
I only suggested parallelly it can go,
Which
but
one?
it's all right.
Milords,
I have no
2
issue.
weeks
Third
from
of
now,
October.
Milords.
Visitation,
Milords, the same order.
visitation,
Yeah, Milords,
visitation rights.
Yes.
Correct.
the same order, 12/7 order.
12/7. Where is that order?
Plus,
The order
12/7 is
page
at
number 20,
26.
26, Milords.
Correct. Learner saying same,
Yes, same.
which is under subdivision.
Next 2 weekends, let them comply with that order. I will convince my clients to go for mediation.
Very well.
All right.
It is in the background of, right, it is in the background of order dated 28. It is in the background of the observations made in order dated 28 to 25, I recall. The contempt petition comes up again. Full stop. Figures on record. The affidavits. Filed by petitioner father. Dealing with the events and happenings occurred during visitation of the child to the place of father on 15 to 25 and 16 to 25. In the detailed affidavit, it is claimed that the children were at ease with the father and the grandparents, and they spent joyful time with them. Post of the affidavit accompanies the photographs capturing the moments as well as the pen drive. Full stop. A further affidavit dated 25, not a further affidavit dated 25 to 25. Has been filed, in which the visitation dated 22 to 25 and 23 to 25 is detailed, and various factual aspects are mentioned. it is to be recorded that the court disapproves the averments made in paragraph 7 of said affidavit dated 25/2/25. Paragraph. Furthermore, though it was recorded in order dated 28/2/25 in paragraph 7 thereof that the learned advocates that learned advocates for the parties had agreed to keep the parties and the children present before the court on 27/2/25, comma, for the reasons transpired and submitted, comma, the court permitted respondent not to permitted the respondent, court exempted the respondent from bringing the children. The